Hello friends, welcome to our channel Law and GK. On this channel, we discuss the contents of law and previous year papers of judiciary and other legal exams. In our previous videos, we have discussed the previous year papers of Haryana, Rajasthan, Uttarakhand. In today's video, we will be discussing Delhi Judiciary previous year paper of 2019. If you are new here, then I would like to recommend you to subscribe to this channel by pressing the subscribe button, and don't forget to press the bell icon. Now let's move towards the question paper. This one is booklet series number B. This is a little preview of the question paper, first page of the question paper. Some general instructions are given to the candidate. Main ones are that the question paper is of 2 hours and 30 minutes, plus in addition to that you are given 15 minutes time to read out the question paper, and there will be 200 objective type questions. 4 options will be given, and you are allowed to use only blue and black point pen only. An important one is that there will be negative marking of 25%, that is for every wrong answer 0.25 marks will be deducted. And here you will be required to write your roll number, your application number, name and signature. Now, so without further ado, let's start the paper. Question first. Alibi is governed by Section 6 of Indian Evidence Act, or option 2, Section 8 of Evidence Act, Section 11 of Evidence Act, or Section 12 of Indian Evidence Act. So it is a very simple question. Alibi is governed by Section 11 of Indian Evidence Act. So right answer is option number 3. Okay. So what does the Section 11 says? It says that when facts not otherwise relevant becomes relevant. In other words, it is rule of alibi. Now, what does Section 6 talks about? Section 6 talks about relevancy of fact forming part of same transaction. And what does Section 8 talk about? Section 8 talk about motive, preparation and previous or subsequent conduct. Motive, preparation, previous or subsequent conduct. And what does Section 12 of Indian Evidence Act talk about? In suits for damages, facts standing to enable court to determine amount are relevant if they are inconsistent with any fact in issue or relevant fact, or second, if by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Now, question second. Communication without prejudice are protected by which section? Section 21 of Indian Evidence Act, or 22, or 23, or 24. So what does the Section 21 says? Section 21 of Indian Evidence Act talks about proof of admissions against person making them and by or on their behalf. Okay, and Section 22 is when oral admissions as to contents of documents are relevant. And Section 23 is the right answer, that is communication without prejudice is protected by Section 23. And what does the Section 24 says? It says that confessions caused by inducement, threat or promise when irrelevant in criminal proceedings. So right answer is option number 3, Section 23 of Indian Evidence Act. Question number 3. Under Section 27 of Indian Evidence Act, the whole statement is admissible. Only the portion of the statement which leads to the discovery is admissible. Or third, both 1 and 2 are admissible, or option 4, none of the above are admissible. So Section 27 of Indian Evidence Act talks about how much of the information received from the accused may be proved. The right answer is option number 2. Only the portion of the statement which leads to the discovery is admissible. Information given by the accused person to police officer leading to discovery of a fact which may or may not prove incriminatory has been made admissible under Section 27 of Indian Evidence Act. Okay, and Section 27 also provides that confessional statement made to the police officer or while an accused is in police custody can be proved against him if the same leads to discovery of the unknown fact. Now question number 4 A dying declaration to be admissible must be made to whom? Magistrate, doctor, police officer, or all of the above. The right answer is option number 4, all of these. And where it is mentioned under section 32, comment section 3 me, okay, of Indian Evidence Act. Now question number 5, the opinion of an expert is relevant under which section? Section 45, 46, 47 or 48? It is relevant under section 45 of Indian Evidence Act. The right answer is option number 1. And what is in section 46, 47 and 48? Section 46, it talks about the facts bearing upon the opinions of the experts, and 47 talks about the opinion as to handwriting when relevant, and section 48 talks about opinion as to existence of right or custom or when relevant. Now question number 7, legal advisor can disclose the professional communication after the death of his client, or can disclose the professional communication after the relationship with the client has ended, can disclose professional communication if made in furtherance of any illegal purpose, or option 4, can disclose the professional communication in all the above instances. The right answer for this is option number C, can disclose the professional communication if made in furtherance of any illegal purpose. Here section 126 talks about professional communication, and this is mentioned in its proviso that any illegal purpose or an effect observed by any barrister, pleader, attorney or vakil in the course of his employment, as such showing that any crime or fraud has been committed since the commencement of his employment. Okay, these two are the reasons when the legal advisor can disclose the professional communication made with his client. Now question number 8, power of the court to suo motu examine any person at any stage is under which section? Section 163, 164, 165 or 167? The right answer here is section 165 of Indian Evidence Act. And what does the other section talks about? Section 163 of Indian Evidence Act says that giving as evidence of any document called for or produced on notice, and section 164 is using as evidence of any document production of which was refused on notice, and 167 is no new trial for improper admission or rejection of the evidence. Right answer is here section 165. Now question number 9, under section 116 of Indian Evidence Act, the tenant is stopped from denying the title of landlord during the continuance of tenancy, before the creation of tenancy, after surrender of possession, or all of the above. Here the right answer is option number 1st, during the continuance of tenancy, and it is mentioned under section here 116, which says that estoppel of tenants and of license of person in possession. No tenant of any immovable property or person claiming through such tenant shall, during the continuance of his tenancy, be permitted to deny that the landlord of such tenant had at the beginning of tenancy a title to such immovable property. Now question number 10, a fact under section 3 of Indian Evidence Act means and includes anything capable of being perceived by senses. Option 2, state of things capable of being perceived by senses. Option 3, relation of things capable of being perceived by senses, or option 4, all of the above. The right answer here is option 4, all of the above, because section 3 of Indian Evidence Act says that fact means and includes anything, state of things or relation of things capable of being perceived by the senses, or any mental condition of which any person is conscious. Right? Now come to question number 11. An accomplice is a competent witness under which section? Section 118, 119, 132 or 133 of Indian Evidence Act. It is a question from chapter 9 of Indian Evidence Act, which talks about witnesses. Accomplice comes under which section? Section number 133 of Indian Evidence Act. Right answer is option number 4, 133. And what does the other section talks about? Section 118 talks about who may testify. Okay, 119 talks about witness unable to communicate verbally. Now 132 talks about witness not excused from answering on the ground that answer will criminate. Now question number 12. Question of title to an immovable property in a suit under section 6 of SRA is relevant, irrelevant, both depending upon the facts of the case, or none of the above. Here the right answer is option number B, irrelevant. Now question number 13. An injunction can be granted to prevent the breach of a contract, the performance of which would not specifically enforced to prevent a continuing breach in which the plaintiff has acquiesced to restrain any person from applying to a legislative body, or none of the above. Here important thing is that an injunction can be granted, whereas in section 41 it is mentioned that injunction when refused, or an injunction cannot be granted. Then these are the answers. Otherwise here it is, the question is can be granted, then the answer will be none of the above. Now question number 14. Mandatory injunction is governed by which section? Mandatory injunction is governed by whether section 38, 39, 40 or 41 of SRA. So the right answer here is option number 2, section 39 of SRA. And what does the other section talks about? Section 38 says perpetual injunction when granted, and section 40 talks about damages in lieu of or in addition to injunction, and 41 talks about injunction when refused. Now the next question number 15. A suit for declaration without seeking consequential relief is barred by which section? It is barred by section 34 of SRA. And what does the other section talks about? Section 37 is what? Temporary and perpetual injunctions. And section 39 is mandatory injunctions. And section 28 says that rescission in certain circumstances of contract for sale or lease of immovable property, the specific performance of which has been decreed. Okay, the right answer here is 34. Suit for declaration without seeking consequential relief. Now question number 16. A mandatory injunction is in nature of what? Restitution, probation, or 1 and 2, or none of the above. Right answer is option number 3, both 1 and 2, both restitution and prohibition. Question number 17. Contract for sale of a Maruti Ciaz car can be specifically enforced, cannot be specifically enforced, only damages can be claimed, or option 4, both 2 and 3. Well, this one was controversial question actually. In DJS final answer key, its answer was given option number 1, which is specifically enforced. But its answer should be which one? Option number 2, cannot be specifically enforced, because section 8 of SRA says that a person can seek specific performance in certain cases, where clause B says that when compensation in money would not afford adequate relief for the loss of the thing claimed, and clause C says that it would be extremely difficult to ascertain actual loss of the thing claimed. Further, Ciaz car is not an article which can be considered as a rare one, which is not available in market, or if available then very rarely. Ciaz car is generally available car which can be purchased from anywhere, and if there is a breach of delivery of Ciaz car, then compensation could be granted adequately, right? So this one is controversial question. Answer key mein right answer was 1, but according to my explanation given to you, the right answer should be option number 2. Now next question 18th. Contract not specifically enforced are enumerated in section 11, 12 or 13 or 14. Which section of SRA? Contracts not specifically enforceable, these are mentioned under section 14 of SRA. And section 11 of SRA, cases in which specific performance of contract connected with trusts enforceable. And 12 talks about specific performance of part of contract. And 13, rights of purchaser or lessee against person with no title or imperfect title. Now next question number 19th. Which contract cannot be specifically enforced? A contract which is in its nature determinable, A contract which is so dependent on the personal qualification of the parties that the court cannot enforce specific performance of its material terms, both 1 and 2, or contract of sale of immovable property. The right answer is option number 3, both 1 and 2. That is a contract which is in its nature determinable, and a contract which is so dependent on personal qualification of the parties that court cannot enforce specific performance. Okay. Now question number 20. The Maharaja of princely state of Jammu and Kashmir, under whose reign the instrument of accession was signed on 26th of October 1947, was Hari Singh, Harvinder Singh, Harish Singh or Karan Singh? The right answer here is option number 1, Hari Singh. Now next question, question 21. Which of the following refers to a special fund initiated by Delhi High Court for victims of burn related injuries? It is option number 2, Asra. Now next question, question 22. According to Supreme Court number of judges Amendment Bill 2019, the maximum number of judges of the Supreme Court of India has been increased from 30 to which number? 31, 32, 33 or 34? Right answer is option number 3, 33, which excludes the Chief Justice of India. Okay, if we include Chief Justice, then the total number is 34. And who is the current Chief Justice of India? Is N.V. Ramana. Okay, this is also important. Now question number 23. In April 2019, Julian Assange was arrested by London Metropolitan Police from embassy of which country? Salvador, Ecuador, Estonia or Equatorial Guinea? The right answer here is option number 2, Ecuador. Now question number 24. The Indian Legal History Museum is located in which city? Ahmedabad, Gandhinagar, Rajkot or Vadodara? The right answer here is Gandhinagar. Next question 25. Which state has recently passed the anti-mob lynching bill? Rajasthan, Maharashtra, Madhya Pradesh or Uttar Pradesh? Right answer is Rajasthan. Question 26. Which among the following countries recently allowed women to travel abroad without approval of a male guardian? Kuwait, Yemen, Saudi Arabia or Oman? The right answer is option 3, Saudi Arabia. Next question 27. Donald Trump accused 2 countries of exploiting the WTO's developing economies tag. Which are the 2 countries? China, Taiwan, India, China, India, Pakistan or Bangladesh and Pakistan? The right answer is option number 2, India and China. Question 28. Wing Commander Abhinandan Vardhaman was felicitated with which one of these honors? Veer Chakra, Paramveer Chakra, Mahavir Chakra, Shaurya Chakra? The right answer is option number A, Veer Chakra. Next question 29. Which of the following chief ministers of Delhi initiated the Bhagidari project to provide better public services by promoting civic participation? Sushma Swaraj, Sahib Singh Verma, Arvind Kejriwal, Sheila Dikshit? The right answer here is option number 4, Sheila Dikshit. Next question 30. Tobacco companies in the USA exercise the rights listed in this to prevent the display of graphic warning on cigarette packets. Which one is the correct option? First Amendment, Second Amendment, Third or Fourth Amendment? The right answer is First Amendment, option number 1. Now question 31. Which of the following was the first woman to hold the office of Ministry of External Affairs in India? Sushma Swaraj, Indira Gandhi, Vijay Lakshmi Pandit or Sheila Dikshit? Right answer is option number 2, Indira Gandhi. Next question. Who was the first women judge in the Supreme Court of USA? Ruth Bader Ginsburg, Sonia Sotomayor, Sandra Day O'Connor or Elena Kagan? The right answer is option number 3, Sandra Day O'Connor. Question number 33. Which of the following has come to be associated with the 2019 Hong Kong pro-democratization protests? Bloodied eye patch, sunflowers, 3-finger salute or fists in the air? The right answer is option number 1, bloodied eye patch. The next question, question number 34. The commission that drafted the Indian Penal Code in 1834 was headed by Barnes Peacock, T.B. McCloy, Stafford Cripps or William Jones? The right answer is option number 2, T.B. McCloy. Next question 35. The recently deceased Nobel Prize winning author Toni Morrison won the Pulitzer Prize for the fictional work in the year 1988. Identify the work. The Bluest Eye, The Song of Solomon, Beloved, The God Help the Child. The right answer here is option number 3, Beloved. Next question 36. Who was one of the first female judges in the British Empire and the first female judge in the Indian High Court? Sujata Manohar, Fatima Bibi, Anna Chandy, and Ruma Pal. The right answer is option number 3, Anna Chandy. Next question. Who is the Indian women sports person to be recommended as Padam Vibhushan? Mary Kom, Kamlajit Sandhu, P.T. Usha, Anju, Bobby George. Right answer is option number 1, Mary Kom. Next question. The US Secretary of the State is Mike Pompeo, Rex Tillerson, John J. Sullivan, or none of the above. Right answer is Mike Pompeo. Okay, but after him, the next US Secretary was Daniel Bennett Smith. Okay, but he became the secretary only for 6 days. Then he left. Now, if the current one is asked, then the right answer is Antony Blinken. Okay, he is the current US Secretary of the State. Now, question number 39. In 2019, India imposed 200% customs duty on goods imported from which country? Pakistan, China, USA, or Nepal? The right answer is Pakistan. Next question is question number 40. The present UN Secretary General is option 1, Antonio Guterres, or B, Ban Ki-moon, 3, Kofi Annan, or none of the above. The right answer is option number 1, Antonio Guterres. Next question, question number 41. India ratified the Kyoto Protocol to the UN Framework Convention on Climate Change in the year 1997, 2010, 2017, or 2000. Right answer is option number 3, 2017. Actually, the Kyoto Protocol was adopted on 11 December 1997. Okay? And India signed it in the same year. India ratified the Kyoto Protocol in 2017. Okay? On 8th of August. 8th August 2017. The second commitment period of Kyoto Protocol on containing the emission of greenhouse gases. Okay. Question number 42. Which state first adopted the Panchayati Raj system in 1959? Rajasthan, Karnataka, Gujarat, or Punjab? The right answer here is Rajasthan. Option number 1, Rajasthan, by 73rd Amendment. 73rd Amendment of the Constitution. Okay. And it was based on the recommendation of whom? Balwant Rai Committee. If it is asked, the committee's name is asked, then it is Balwant Rai Committee. Now the next question, question number 43. The current Lok Sabha is the 15th, 16th, 17th, or 18th. The current Lok Sabha period is 17th Lok Sabha. Question number 44. The governor enjoys the office at the pleasure of the Parliament, Legislative Assembly, President, or Supreme Court. Right answer is option number 3, President, at the pleasure of the President. Now next question 45. The current Chief Economic Advisor to the Government of India is, remember that this was asked in 2019. So that time it was option number 3, Krishnamurthy Subramanian. But right now, who is the Chief Economic Advisor to Government of India? He is V. Anantha Nageshwaran. And he is appointed on 28th of January 2022. Okay. So important question from this perspective. V. Anantha Nageshwaran. Next question, question number 46. The total number of schedules in the Indian Constitution are 6, 14, 12, or 10. Right answer is option 3, 12. Simple question. Next question, question number 47. The total number of high courts in India at present are 20, 25, 30, or 35. The right answer is 25 high courts. Now next question, question number 48. In 2019, India won a major dispute against the USA at WTO. The subject matter dealt with was renewable energy program, steel industry, auto industry, or poultry industry. The right answer is option number A, renewable energy programs. Next question, question number 49. The RCEP treaty negotiations concern the subject matter of nuclear non-proliferation, free trade agreement, environment treaty relating to hazardous substances, or none of the above. First of all, what is RCEP? It is Regional Comprehensive Economic Partnership. Its treaty negotiation subject matter was free trade agreement. Right answer is option number 2, free trade agreement. Now next question, question number 50. Gangubai Hangal was well-known exponent of which of the following genres of music? Thumri, Dhrupad, Khayal or Tharna? The right answer is option number 3, Khayal. Now next question, question number 51. Parliament's lack of power to alter the basic structure of the constitution was propounded for the first time in which case? Sajjan Singh versus State of Rajasthan, Keshwanand Bharti versus State of Kerala, I.C. Golaknath versus State of Punjab, or Minerva Mills versus Union of India. The right answer is option number 2, Keshwanand Bharti versus State of Kerala. Very important case. Now next question, question number 52. In which of the following cases a partnership does not exist? Does not exist. Lender of a money receiving profits, servants or agents receiving profits, widow or child of a deceased partner receiving profits, seller of a goodwill receiving profits. So it is section 6 of Partnership Act. It say the receipt of such share or payment by the lender of money to persons engaged or about to engage in any business, B, any servant or agent as a remuneration, or C point, by the widow or child of a deceased partner as immunity, and D point, by a previous owner or part owner of the business as consideration for the sale of goodwill or share thereof. Now important point comes, it says that does not itself make the receiver a partner with the persons carrying on the business. So does not make a partner, right? So the right answer here is option number 4, all of the above, doesn't make them a partner. Next question, question number 53. A partner cannot contract himself out of which of the following duties? Duties comes under section 9 of Partnership Act, which says general duties of partner. Section 9 says that partners are bound to carry on the business of the firm to the greatest common advantage, to be just and faithful to each other, and to render true accounts and full information of all the things affecting the firm to any partner, his heir or legal representative. Okay, so according to section 9, duty of utmost good faith is there, duty to carry on business to greatest common advantage, render true accounts and full information. Okay, so these 3 points are comes under section 9 of Partnership Act. And what does the section 10 say? Partnership Act, duty to indemnify for the loss caused by the fraud. Every partner shall indemnify the firm for any loss caused to it by his fraud in the conduct of business of the firm. So section 10 talks about indemnify for fraud. It is section 10. So the right answer here is option number what? First is correct, second, third and fourth. So right answer here is option 3. First, second, third and fourth. Next question, question number 54. Notice one partner operates as notice to the whole firm. However, the note must have been given to a partner who habitually acts in the business of the firm. Notice to a dormant or sleeping partner would also suffice. Notice to a partner who commits a fraud on the firm will not be a notice to the firm, or option D. Both 1 and 3 are correct. Now important point here is notice to one partner. Where is the notice mentioned in Partnership Act? So notice is nowhere defined, right? So the notice must have been given to a partner who habitually acts in the business of the firm. It will be operated as notice to the firm. But if it is given to partner who commits the fraud, then it will not be operated as a notice to a firm, but it will be operated as notice to that defaulting partner only. So the right answer here is what? Option number 4. Both 1 and 3 are correct. Now the next question, question number 55. If a person fails to comply with the terms of a notice for appearance under section 41A1 of the Code of Criminal Procedure, or is unwilling to identify himself, the police officer, option 1, may, subject to such orders as may have been passed by the competent court in his behalf, arrest him for the offence mentioned in the notice. Option 2, shall arrest him for the offence mentioned in the notice. Option 3, may not arrest him for the offence mentioned in the notice. Or option 4, may without an order from magistrate and without a warrant arrest him. So the right answer here is option number 1, because according to the section 41A1 of CRPC says that if a person fails to comply with the terms of the notice or for appearance or is unwilling to identify himself, the police officer may subject to such orders as may have been passed by the competent court. In this behalf, arrest him for the offence mentioned in the notice. Okay, next question is question number 56. The memorandum of arrest to be prepared by every police officer while making an arrest shall be: option A, attested by at least 2 witnesses, one of which shall be a member of family arrested, or attested by at least 2 witnesses, one of which is a member of a family of a person arrested and the other is a gazetted officer living in a locality where the arrest is made. Option 3 is attested by at least 1 witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made, or and shall be countersigned by the person arrested. Or option 4, as far as may be possible in the circumstances in which arrest is made, attested by at least 1 witness. So memorandum of arrest, it is section number 41B of CRPC, which says that every police officer while making an arrest shall bear an accurate, visible and clear identification of his name, which will facilitate easy identification. And then point B जो है ना section 41B का, which says that prepare a memorandum of arrest shall be attested by at least 1 witness who is a member of the family of the person arrested or a respectable member of locality where the arrest is made. And second point is countersigned by the person arrested. And point C says inform the person arrested unless the memorandum is attested by a member of the family that he has a right to have a relative or a friend named by him to be informed of his arrest. Okay, so here the right answer is option number 3, at least 1 witness who is a member of a family of the person arrested or a respectable member of the locality where the arrest is made and shall be countersigned by the person arrested. So it is option number 3, section 41B and point number B of section 41B. Next question 57. When any offence is committed in the presence of a magistrate within his local jurisdiction, he may only direct a police officer posted in the police station with his local jurisdiction to arrest the offender, order and only a gazetted officer to arrest the offender, himself arrest, or order any person to arrest the offender, or none of the above. The right answer here is third option, himself arrest or order any person to arrest the offender, and it is mentioned under section 44(1) of CRPC, which says that when any offence is committed in the presence of magistrate, whether executive or judicial, within his local jurisdiction, he may himself arrest or order any person to arrest the offender. Next question is question number 58. If any court has a reason to believe that any person against whom a warrant has been issued by it has absconded so that such a warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and a specified time, not less than how much period from the date of publishing such proclamation. So this is basically section 82(1) of CRPC. Okay, 82. The right answer here is 30 days, option number 2. Next is compensation can be awarded to the victim of a penal offence under dash of the Code of Criminal Procedure. So here the right answer is section 340, 357, 357A, both 2 and 3. So right answer here is option number 4, both 2 and 3, section 357 and 357A both, which talks about order to pay compensation. And what does the section 340 says? Section 340 talks about the procedure in the cases mentioned in section 195, which says that prosecution for contempt of lawful authority of public servants, for offences against public justice, and for offences relating to documents given in evidence. Okay, right answer here is section 357 and 357A, which talks about order to pay compensation. Next question, question number 60. An order for monthly allowance for maintenance or interim maintenance and expense of a proceeding under section 125 of Code of Criminal Procedure shall be payable from the date of order, from the date of application for maintenance or interim maintenance and expenses of proceedings from the date of the order, or if so ordered from the date of application for maintenance or interim maintenance and expenses of proceeding, or from date as the magistrate may deem fit and proper. Right answer here is option number 3, and it is mentioned under section 125 of CRPC, which talks about maintenance and expenses. It says that it shall be payable from the date of the order, and if so ordered, from the date of application for maintenance or interim maintenance and expenses of proceedings. Right, now next question, question number 61. An order for alteration in the allowance of for the maintenance or interim maintenance can be made by the magistrate under section 127 of CRPC on the proof of change in circumstances at the instance of what? Option A, any person receiving under section 125 a monthly allowance for maintenance or interim maintenance. Any person ordered under section 125 to pay monthly allowance for the maintenance or interim maintenance. Option 3, relative of any person ordered under section 125 to pay monthly allowance for the maintenance or interim maintenance. Or option 4, both 1 and 2. Here the right answer is option number 4, both 1 and 2. And it is mentioned under section 127, which says that alteration in the allowance on proof of a change in the circumstances of any person receiving under section 125 a monthly allowance or ordered under the same section to pay monthly allowance to his wife, child, father or mother, as the case may be, the magistrate may make such alteration in the allowance as he thinks fit. Next question, question number 62. Which of the following statements is false in the context of section 155 of CRPC? Regarding investigation of non-cognizable cases, no police officer shall investigate a non-cognizable case without the order of the magistrate having a power to try such case or commit the case for trial. Any police officer receiving such order may exercise the same powers in respect of the investigation, including the power to arrest without warrant, as an officer in charge of police station may exercise in cognizable case. Option 3, where a case relates to 2 or more offences of which at least one is cognizable, the case shall be deemed to be cognizable case, notwithstanding that the other offences are non-cognizable. Option 4, upon the receipt of information of the commission of non-cognizable offence, the officer in charge of the police station shall enter the substance of information in a book in such form as the state government may prescribe in this behalf. So the right answer here is option number 2, which is a false statement, because according to section 155 subsection 3, it says that any police officer receiving such order may exercise the same powers in respect of the investigation except the power in arrest without warrant, as an officer in charge of the police station may exercise in a cognizable case. Now the next question, question number 63. A magistrate may take cognizance under section 190 of CRPC of any offence upon receiving a complaint of the facts which constitute such offence, or upon his knowledge that such offence has been committed, upon a police report of such facts, upon information receiving from any person other than the police officer that such offence has been committed, or all of the above. The right answer here is option number 4, all of the above, because according to section 190 of CRPC, which is cognizance of offences by magistrate. Next question, question number 64. In a case, an application for bail is filed by the accused who is alleged to have committed an offence under section 376 AB of Indian Penal Code. In such a case, it is mandatory to give a notice of such bail application before granting bail to the public prosecutor within a period of 15 days from the date of receipt of notice of such application, within a period of 7 days from the date of receipt of such notice of application. Or option number 3, not mandatory to give notice to public prosecutor if the complaint or informant is represented through a private counsel. Or option number 4, not mandatory to give notice to public prosecutor if the court considers that it is not practicable to give such notice. So the right answer here is option number 1, because according to section number 439(1) of CRPC, its second proviso says that the High Court or Court of Session shall, before granting bail to an accused under section 376 of IPC, give notice of the application for bail to the public prosecutor within 15 days from the date of receipt of such a notice of application. So this thing is provided under section 439(1) and second proviso. Next question, question number 65. Any court may alter or add to any charge before examination of an accused under section 313 of CRPC, after examination, before examination of any prosecution witness, or at the time before the judgment is pronounced. Right answer is option number 4. Before the judgment is pronounced, and it is mentioned under which section? It is provided in section 216 of CRPC. Next question, question number 66. When in a warrant case instituted otherwise than on a police report, the accused appears or is brought before the magistrate shall satisfy himself that he has complied with the provisions of section 207 of CRPC, postpone issue of process against the accused if he is residing at a place beyond the area in which he exercises his jurisdiction, either inquire into a case himself or direct an investigation to be made by the police officer for the purpose of deciding whether or not there is a sufficient ground for proceeding, or option 4, shall proceed to hear the prosecution and take all the evidence as may be produced in the support of the prosecution. The right answer is option number 4, shall proceed to hear the prosecution and take all such evidence as may be produced in the support of the prosecution. It is mentioned under which section? Section number 244(1) of CRPC, evidence for prosecution. It is mentioned there. Next is question number 67. When in a summons case the accused appears or is brought before the magistrate, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused. Or option 2, the magistrate shall frame in a writing a charge against the accused if, upon considering the police report and the documents sent with it and making such examination as the magistrate thinks necessary, the magistrate is of the opinion that there is a ground for presuming that the accused has committed an offence, the particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge, or option number 4, none of these. So the right answer here is option number 3. The particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge. And it is mentioned where? It's section 251(1) of CRPC. Substance of accusation to be stated. Now the next question, so question number 68. Section 293 of CRPC regarding reports of government specific experts applies to whom? The director of a central or state forensic science laboratory, the deputy director of the same, the assistant director of the same, or option number 4, all of the above. The right answer here is option number 4, all of the above. Now the next question, question number 69. The authorities under section 297 of CRPC before whom affidavits may be sworn to be used before any court under CRPC may be sworn or affirmed before any judge or judicial or executive magistrate, any commissioner of oaths appointed by the High Court or Court of Session, any notary appointed under Notaries Act 1952, or all of the above. The right answer is all of the above. Okay. Next question is question number 70. The Court of Sessions shall ordinarily hold its sitting as per section 9 of CRPC. So the right answer here is option number 2. At any such place by notification or in particular, the court is of the opinion tend to general convenience. Okay. It is mentioned under section 9 only. Now next question. Question number 71. The amount of compensation which a magistrate can direct the complainant or informant to pay for an accusation without reasonable cause under section 250 of CRPC is not exceeding 5,000 rupees, not exceeding rupees 15,000 as he may determine, but not exceeding the amount of a fine he is empowered to impose, or option number 4, not exceeding the amount of fine he is empowered to impose for the particular offence for which the accusation was made without a reasonable cause. The right answer is option number 3, as he may determine but not exceeding the amount of fine which he is empowered to impose. Alright, it is mentioned where? Mentioned under section 250 subsection 2 of CRPC. Next question. Question number 72. The withdrawal of the complaint in a summons case under section 257 of CRPC results in acquittal of accused, discharge of accused, acquittal or discharge depending upon the stage at which the withdrawal is permitted, acquittal after the charge has been framed and a discharge before charge has been framed. The right answer here is option number 1, acquittal of the accused, because according to section 257 CRPC, withdrawal of the complaint if a complainant at any time before a final order is passed in any case under this chapter satisfy the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint is so withdrawn. So acquittal of accused. Now the next question, question number 73. Any metropolitan magistrate may, if he thinks fit, try in a summary way the following of the offences under section 260 of CRPC: theft under section 379, 380, 381 of IPC, where the value of the property stolen does not exceed how much amount? 2000 rupees, or offences relating to 454, 456 of IPC, receiving or retaining stolen property under section 441 of IPC, where the value of the property does not exceed 2000 rupees, or all of the above. The right answer is option number 4, all of the above, and it is mentioned where? Under section 260 subsection 1 clause C. Next question, question number 74. And section 363 of CRPC entitles a person accused of any offence to receive a copy of judgment free of cost when he is convicted of the offence, when he is sentenced to imprisonment, when he is confined in a jail after being sentenced to imprisonment, or option 4, when he is represented by a legal aid counsel. The right answer is option number 2, when he is sentenced to imprisonment. And it is mentioned where? It is mentioned under section 363 of CRPC. It is provided that free copy of judgment when a person is sentenced to imprisonment, right? Next question is question number 75. In calculating fractions of the term of punishment, section 57 of IPC prescribes that imprisonment for life shall be reckoned as equivalent to imprisonment for how much years? It is 20 years. Option number 3, 20 years. Now next question, question number 76. The maximum term of imprisonment which can be imposed by the court for the offence under section 304A of IPC is 3 years, 2 years, 1 year, or 6 months. So first of all, what's in section 304A? It is causing death by negligence, right? So what does the section say? It says that causing death by negligence, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with how much imprisonment? Imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. So it is already mentioned in section 304A. Then the right answer is 2 years. Okay, next question, question number 77. Under section 63 of IPC, where no sum is expressed to which a fine may be extended, then the amount of a fine to which the offender is liable is prescribed as option 1, limited up to rupees 1 lakh, limited up to rupees 50,000, limited to such amount as appropriate the government may prescribe, unlimited but is directed not to be excessive. So here the right answer is option number 4, unlimited but is directed not to be excessive, and it is mentioned in section 63. Next question, question number 78. Where an offence is punishable with imprisonment as well as fine, the term for which the court can direct the offender to be imprisonment in default of payment of fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offence, 1/4 of the term of imprisonment to which the offender has been sentenced, or 1/5 of the term of imprisonment to which the offender has been sentenced, or 1/5 of the term of imprisonment which is the maximum fixed for the offence. So this is about section 65 of IPC. So the right answer according to that section is option number 1, 1/4 of the term of imprisonment which is the maximum fixed for the offence, right? Now next question, question number 79. In which case did the Supreme Court first hold that the right of a victim to file an appeal under the proviso to section 372 of a CRPC is available against orders of acquittal rendered after 31 December 2009, and that for exercising such right no leave to appeal is required to be sought. It talks about which case? First of all, you must know that what is mentioned in section 372 of CRPC. Section 372 says that no appeal to lie unless otherwise provided. That is, where no appeal shall lie from any judgment or order of a criminal court except as provided by this code or any other law for the time being in force. So, this was discussed in the case of Mallikarjun Kodagli versus State of Karnataka. Now next question, question number 80. In which case did a 5-judge constitution bench of the Supreme Court consider the ambit and scope of section 319 of CRPC? What does the section 319 of CRPC says? It talks about the power to proceed against persons appearing to be guilty of the offense. Right? So the right answer here is the case was Hardeep Singh versus State of Punjab. Now next question, question number 81. A instigates B to burn Z's house. B sets fire to the house, at the same time commits the theft of the property there. In such a case, A would be, so this is basically illustration of which section of IPC? Section 111 of IPC, right? It is illustration B. What does section 111 of IPC talks about? Liability of abettor when one act abetted and a different act is done. So right answer here is guilty of abetting burning of the house but not guilty of abetting of the theft. Next question, question number 82. The ambit and scope of the offense of sedition under section 124A of IPC was considered by 5-judge bench Supreme Court in the case of which case? Kedarnath Singh versus State of Bihar. Next question, question number 83. Very important question, very much asked in the papers. A knows Z to be behind a bush. B does not know it. A intending to cause or knowing it to be likely to cause Z's death induces B to fire at the bush. B fires and kills Z. Here B has committed the offense of culpable homicide. A has committed the offense of abatement. B has committed the offense of causing death by negligence. B may be guilty of no offense, but A has committed the offense of culpable homicide. Right answer is option number 4. B guilty of no offense, but A has committed the offense of culpable homicide. This is mentioned under section 299 of IPC, and this is exactly illustration B of that section. Now question number 84. The offense of voyeurism under section 354C of IPC is committed when a man commits the act of physical contact and advances involving unwelcome and explicit sexual overtures, a man makes sexually colored remarks, a man who monitors the use by a woman of internet, email or any other form of electronic communication, any man who watches or captures the image of a woman engaging in a private act in the circumstances where she would usually have the expectation of not being observed either by perpetrator or by any other person at the behest of the perpetrator, or disseminates such image. So voyeurism is basically what? It is exactly mentioned in section 354C. This thing is exactly mentioned. The right answer is option number 4. One more thing important here, that what is mentioned in section 354 of IPC, that whoever commits the crime of voyeurism, then commits the crime for first time, then the punishment is for 1 year, which may extend to 3 years, and shall liable to fine also. But if he is a subsequent conviction, okay, he is committing it for the second time, then the punishment is not less than 3 years, which may extend to 7 years, and shall be liable to fine. This thing is also important, that first time if he commits it for the first time, then the punishment is from 1 year to 3 years, and if it is committed for the second time, then it is minimum 3 years and up to 7 years plus fine. Next is question number 85. Hurt as defined in section 319 of IPC is causing of the following to any person: bodily pain, disease, infirmity, or all of the above. The right answer is option number 4, all of the above. So section 319, which talks about hurt, it says that a person causes hurt if he causes bodily pain, disease, or infirmity to somebody, or in other words, the victim must suffer from physical pain or pain due to the action of the offender. Now next is question number 86. Section 377 of IPC regarding unnatural offences was partially struck down by Supreme Court in which of the following cases? Very important case it is: Navtej Singh Johar versus Union of India, section 377. Next question, question number 87. Stolen property as per section 410 of IPC includes what? It includes property, the possession where has been transferred by the theft, extortion, or robbery; property which has been criminally misappropriated; property in respect of which criminal breach of trust has been committed; or all of the above. Then the right answer here is all of the above. All these kinds of property is included in section 410 of IPC, stolen property. Now next question, question number 88. The offense of cruelty, under which section? Cruelty is under 498A of IPC. Punishes subjecting a woman to cruelty by whom? By the husband or relative of the husband of a woman, any person known to the woman, or whom? All of the above. Then what does the section 498A says? That it is clearly mentioned in that section that the husband or relative of husband of woman subjecting her to cruelty. Then the right answer here is option number 1, husband or relative of the husband of a woman. Okay. Next is question number 89. Section 34 of IPC regarding a criminal act done by several persons in furtherance of common intention of all is a separate offence in itself, punishing separately, is a rule of evidence, and does not create a substantive offence attracted in cases of criminal conspiracy, or both 2 and 3 are correct. Section 34, which is what? It is common intention. The section says that a criminal act done by several persons in furtherance of common intention. Right? The right answer here is option number 2. It's only a rule of evidence and does not create a substantive offense. Right? And what does it provide? It just provide a constructive criminal liability. Now next question, question number 90. The Supreme Court upheld the constitutional validity of the offence of defamation under section 499 of IPC in the case of Subramaniam Swamy versus Union of India. Now next question, question number 91. A intending to murder Z by poison purchases poison and mixes the same with food and delivers it to Z's servant to place it on Z's table. A has committed what? An offense of attempt to murder, an offense of preparation to commit murder, no offense, an offense of culpable homicide not amounting to murder. Attempt to murder is mentioned under which section of IPC? 307 of IPC. Right? So here A has committed the offense of attempt to murder, as he has done an act towards the commission of the offense of murder. So the right answer here is committed an offense of attempt to murder. Now next question, question number 92. The offense of dowry death under section 304B of IPC is committed where the death of a woman is caused by any burns or bodily injury or occurs otherwise than normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of husband. 10 years of marriage and similar thing, 7 years of marriage, and it is shown that before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with or any demand for dowry. Or last option, 7 years of her marriage and it is shown that before her death she was subjected to cruelty or harassment by husband or any relative of her husband, or for the connection with or any demand for dowry. Then the right answer here is option number 3, 7 years of her marriage and it is shown that soon before her death. First condition, she was subjected to cruelty or harassment. Whom? By whom? By her husband or any of the relative of the husband, or in connection with any demand of dowry. Next question, question number 93. Section 317 of IPC punishes the offence of exposure and abandonment of a child under 12 years by parent or person having care of it. Section 304 of IPC provides for punishment for offence of culpable homicide not amounting to murder. Here, A exposes her child with the knowledge that she is thereby likely to cause its death. The child dies in consequence of such exposure. In such circumstances, A may be what? Charged with and convicted of the offences under section 317 and 304 of IPC. Both these sections are already mentioned in the question, and the right answer is also option number 2. Now next question. Question number 94. A intentionally deceives Z into a belief that A has performed A's part of contract and made with Z which he has not performed, and thereby dishonestly induces Z to pay the money. A has committed the offence of criminal breach of trust under section 405 of IPC, or the offence of criminal breach of trust by public servant or banker, merchant, agent under section 409 of IPC, or the offence of dishonest misappropriation of property under section 403 of the code, or the offence of cheating under section 415. Then what he has done here? He has dishonestly induces and deceives Z into a belief, right? So deceive, so what he did is cheating. The right answer is option number 4. Section 415 talks about cheating, and this is exactly illustration number H of that section. Next is question number 95. Section 471 of IPC states that whoever fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be forged document or electronic record shall be punished in the same manner as if he had forged any such document or electronic record. If a person is convicted only for the offence under section 471 of IPC, he will then, option A, be imposed for the offence of forgery of the document in addition to having the same as genuine, be imposed punishment as prescribed for having committed forgery of the document which he used as genuine, or option 3, both 1 and 2 depending on the facts and circumstances of the case, or option D, none of the above. And then section 471, it is already mentioned that what does it talks about. So the right answer here is option number 2, which says that he be imposed for the punishment as prescribed for committing forgery, because he did forgery, right? Forgery of the document which he used as genuine. Now the next question, question number 96. A, having insured a ship, voluntary causes the same to be cast away with the intention of causing what? Causing damage to the underwriters. A has committed the offence of criminal breach of trust under section 405 of IPC, or cheating under 415, criminal misappropriation of property under 403, or mischief under section 425 of IPC. So he has done what? He has intentionally caused damage. So it is mentioned under section 425. This is a case of mischief, and it is the exact illustration F of that section, offense of mischief. Okay, now next question, question number 97. Which of the following statements is false with respect to the offense of defamation under section what? Under section 499 of IPC. It is not a defamation to impute anything which is true concerning any person if it be for the public good. So first thing here is true concerning any person, anything which is true, and it be for the public good, that the imputation should be made or published. Whether or not it is for the public good is a question of fact. Second is, it is defamation to express in a good faith any opinion whatever respecting the conduct of a public servant in the discharge of public functions, or respecting his character so far as his character appears in the conduct and no further. It is not defamation to express in good faith. Here is not defamation if it is expressed in good faith any opinion whatever respecting the conduct of any person, touching any public question, and respecting his character so far as his character appears in that conduct and no further. Or option number 4, it is not defamation in a person having over another any authority either conferred by law or arising out of a law, lawful contract made with that other to pass in good faith any censure on the conduct of that order in the matters to which such lawful authority relates. So here it is defamation to express in good faith any opinion whatever respecting the conduct of the public servant in discharge of his public functions or respecting his character so far as his character appears in the conduct and no further. So if section 499 is exception number second, or it talks about that, it says that it is not a defamation to express in good faith any opinion. So this thing is exception second of section 499 of IPC. So the right answer here is option number 2. Section 90, question 98. A makes an attempt to steal some jewels by breaking open a box and finds after so opening the box that there is no jewel in it. So what is the offense A did? Guilty of no offense as there was no jewel to steal, or guilty of the offense of attempting to commit theft of the jewel as he has done an act towards the commission of theft, or guilty of the offense of committing preparation to commit the offense of theft, or option 4 guilty of theft as it is immaterial whether he could succeed or not, and stealing of some jewels. Then the right answer here is option number 2, guilty of the offense of attempt, because he attempted to commit the theft, whether there are jewels in the box or not, but he has attempted to commit the theft as he has done the act towards the commission of theft. This thing is mentioned under which section? Section 511 of IPC, and this is exactly illustration A of that section. Now question number 99. A begins to unloose the muzzle of a ferocious dog, intending or knowing it to be likely that he may thereby cause Z to believe that he is about to cause the dog to attack Z. A has committed of what offense? Committed no offense, or committed the offense of assault under IPC, committed the offense of attempt to commit assault, or committed the offense of criminal intimidation under the IPC. So this is illustration B. Basically this is illustration B of 351 of IPC. Okay, so the right answer here is option number 2, commit the offense of assault. 351 assault under IPC, exactly illustration B. Now next question, question number 100. The punishment for the offense of forgery of a will is prescribed under which section? It is prescribed under section 467 of IPC, forgery of a valuable security or will. And how much is the punishment mentioned there? The punishment which is mentioned there is shall be punished with imprisonment for life or with the imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. And what does other sections talks about? Section 463 says it gives the definition of forgery, right? Section 463. And 468 talks about forgery for the purpose of what? Cheating. And 467 is already mentioned that offense of forgery of a will. And section 471 talks about using as genuine a forged document or electronic record. Whenever the forged document or any forged electronic record are used somewhere as a genuine document, then they comes under section 471. Okay, next question is question number 101. Dishonestly making false claim in the court is an offense under which section? It is an offense under section 209 of IPC. So the right answer is option number 2, 209 of IPC, which says that dishonestly making false claim in the court. Whoever fraudulently or dishonestly or with the intent to injure or annoy any person makes in a court of justice any claim which he knows to be false. And what is the punishment mentioned there? Then he shall be punished for a term which may extend to 2 years and also fine. And what does section 215 of IPC talks about? It talks about taking gift to help to recover the stolen property. And section 195 of IPC and section 195 of IPC talks about giving or fabricating false evidence with intent to procure conviction of the offense, punishable with imprisonment for life or imprisonment. It is basically giving or fabricating the false evidence. And section 196 of IPC talks about what? Using evidence which is known to be false. So basically, whoever corruptly uses or attempts to use as true or genuine evidence, then he will come under which section? Section 196 of IPC. Now next question, question number 102. A is charged with the offence of causing simple hurt. A pleads guilty to the charge before the Metropolitan Magistrate and is accordingly convicted for the said offence and is sentenced to imprisonment for 1 year. A can file an appeal against the order of conviction and sentence in the Court of Session, against the order of conviction and sentence in the High Court, or against the extent or legality of the sentence in the Court of Session, or all of the above. The right answer here is option number 3, against the extent or legality of the sentence and in the Court of Session, and it is mentioned where? It is mentioned under section 375 of CRPC. It says that no appeal in certain cases when the accused pleads guilty, notwithstanding anything contained in section 374, where an accused person has pleaded guilty and has been convicted on such plea, there shall be no appeal. Where if the conviction is by the High Court, or if the conviction is by the Court of Session, Metropolitan Magistrate, or Magistrate of first class or second class, except as to the extent or legality of the sentence. Except extent or legality of the sentence in the Court of Session, right? So right answer is option number 3. Now next question, question number 103. A is the victim in a gang rape case. At the conclusion of the trial, the accused persons are convicted and sentenced to imprisonment and fine. The court orders the fine amount to be paid to A as compensation. A has also filed an application for compensation under section 357A of CRPC, which is pending consideration before the competent authority. In such a situation, the fine amount cannot be paid to A as compensation since she has already filed an application for compensation under 357 of CRPC. Or option 2, the state government can pay compensation under 357A of CRPC procedure, CRPC, in addition to the payment of fine as compensation to A under section 376D of IPC. So this is the right answer, that she can get compensation where? In section 357A of CRPC, plus fine payment according to section 376D, which talks about gang rape or in IPC. So here the right answer is option number 2 only. Next is question number 104. Statement of a person recorded by magistrate under section 164(5)(a) clause A of CRPC can be taken as a statement in lieu of examination in chief, where the person is a victim in a case punishable with for the offence of kidnapping and victim is mentally disabled. Well, kidnapping is in which section of IPC? It is in 359, 360, 61. And option 2, punishable for the offence of grievous hurt and victim is physically disabled. Grievous hurt is mentioned under 320 IPC. Option 3, punishable for the offence of stalking and the victim is temporarily physically disabled. Stalking is in which section? 354D of IPC. Or option 4, punishable for the offence of voyeurism. Voyeurism is in which section? 354C of IPC. Well, of the same section of 164(5)(b), then it is mentioned that a statement recorded under clause A, which is this statement, a person who is temporarily or permanently mentally or physically disabled. So this is the basically condition there, that the victim should be temporarily or permanently mentally or physically disabled, shall be considered a statement in lieu of examination in chief as specified in the section 137 of Indian Evidence Act, such that the maker of the statement can be cross-examined on such statement without the need for recording the same at the time of trial. And if you see the clause A of the same section, then it is mentioned that in the cases punishable under section 354, 354A, 354B, C and D. So here in the options, which sections are given? 354D and C. Okay, and furthermore it is given that section 376, which is not here in the question. So the right answer here is which option fulfills both the conditions, that crime should be of 354D and the victim should be permanently or physically disabled. So our right answer is option number 3. Plus, if in this option also voyeurism plus If this condition was also fulfilled, then this could be the answer also. Option number 4. Next question, question number 105. A, knowing that B, C, D, E, F and G are about to commit the offense of dacoity in Kathmandu, Nepal, harbors them in his house in Sitamarhi, Bihar, with the intention of facilitating the commission of such dacoity. A has not committed any offense as dacoity was yet to take place, not committed any offense that can be tried. Third option, committed the offense of harboring dacoits, or option number 4, committed an offense which can be tried and punished only in Nepal. So this is basically section 216 of IPC. What does the section say? It talks about the penalty for harboring the robbers or dacoits. So according to that section, this is the offense of harboring the dacoits. The right answer is option number 3, and it is mentioned under where? Under section 216 of IPC. Now next question, 106. A, as an employer deducts his employee's contribution from the wage payable to the employee for credit to the employee's state insurance fund held and administered by the employee's state insurance corporation established under Employees State Insurance Act 1948. A makes a default in the payment of such contribution to the said fund in violation of the said act. A has not committed any offense, committed the offense of criminal breach of trust, committed the offense of criminal misappropriation of property, or committed the offense of theft. What offense did he committed? He committed the offense of criminal breach of trust. Where it is provided criminal breach of trust? It is provided under section 405 of IPC, criminal breach of trust. So the right answer here is option number 2, committed the offense of criminal breach of trust. Next is question number 107. Section 5 of Limitation Act applies to what? Suits, appeal or applications, both 1 and 2, and none of the above. Then section 5 of limitation says that extension of prescribed period in certain cases, and in the beginning of the section it is mentioned that any appeal or application. So the right answer is appeal or application. Section 5 talks about appeal and application. Next, question number 108. The period of limitation for filing a suit for damages for defamation is how much period? 1 year, 2 year, 3 year, or none of the above? Then it is 1 year. And where it is mentioned? It is mentioned under Article 75 and 76 of Limitation Act. Next is question number 109. The period of limitation for filing a suit for possession under section 6 of SRA is 6 months, 1 year, 3 years, or 12 years. Here the right answer is 6 months. And what does section 6 of SRA talks about? It talks about suits by person dispossessed of immovable property. Then no suit under this section shall be brought after the expiry of how much period? 6 months, and against the government, plus no appeal and review can be filed here. So what can be filed then? Only the option of revision is there. Next is question number 110. If no period of limitation is provided in the Limitation Act, the proceedings can be instituted within 1 year, 3 years, 12 years and 2 months, and option 4, none of the above. The right answer for this is option number 2, 3 years, and it is mentioned under Article 137 of Limitation Act. Next is question number 111. Suit for arrears of maintenance can be filed within how much period? 1 year, 2 years, 3 years, or none of the above? It is mentioned under Article 105. This thing is given in Article 105 of Limitation Act, and the right answer for this is 3 years. Next is question number 112. The period of limitation for filing leave to defend in a suit under Order 37 of a Code of Civil Procedure within how much period? 10 days of receipt of summons for judgment, 30 days of receipt, or 90 days, or 120 days. First of all, understand what does this order talks about. Order 37 of CPC. What is it? It is summary procedure order, right? And this thing is mentioned under Article 108 of Limitation Act. Article 108, and the right answer for this is option number 1, 10 days. Next is question number 113. The period of limitation for filing an application for review. Review is how much period? 30 days, 60 days, 90 days, or 120 days. This thing is mentioned under Article 122 of Limitation Act, and the right answer for this is option number 1, 30 days of the judgment or order. Next is question number 114. The period of limitation for filing revision petition to the High Court under section 115 of the Code of Civil Procedure is 30 days, 60 days, 90 days or 180 days. The earlier question it was asked about review, and here it is asked about for filing revision petition to High Court. So the right answer here is option number 3, 90 days of order or judgment. And where it is mentioned under Article 131 of Limitation Act. You must understand that these articles are very important of Limitation Act besides the sections. Next is question number 115. If the defendant is abroad during the period of limitation, such period is excluded from the period of limitation, such period is included, such period is excluded from the period of limitation only if the period of stay abroad is more than 30 days, or option number 4, none of the above. The right answer for this is such period is excluded from the period of limitation. The right answer is option number 1, and where it is mentioned under section 15(5) of Limitation Act. Now comes to question number 16. He is a lazy person and wants a touch of spur. The italicized phrase in the above sentence means option 1, wants to get everything easily, option 2, wants to retire to bed, option 3, wants a rousing up, or option number 4, wants his work done by someone. He is a lazy person and want a touch of spur. So it means option number 3, wants rousing up. Next is question number 170. The faculty for myth is innate in human race. Faculty in the above sentence most nearly means what? Capacity, branch of learning, authority or teaching. It is right answer here is capacity. The next question number 118. These seats are set dash for ladies. The High Court set dash the sentence. The winter has now set dash. It is quite confusing. You must understand that the options are about, aside, on, and second option of, fourth, in, and third is on, apart, fourth, and fourth is apart, aside, in. So let's set up the sentences. These seats are set what? Set apart for ladies, and the High Court set aside the sentence. The winter now is set in. Okay, so the right answer here is option number 4. Next is question number 119. Pick the list of correctly spelt words. The correctly spelt words. So in these type of questions, you must firstly notice only the first word. Okay, then comes to second, then third or fourth. Because in most of the cases, if you find that first word is wrong, then there is no need to go for the other options. So let's check it out. Experience. What is the correct spelling of experience? EXPERIENCE. Right. This one is right. Receive. Right. Acquisize. Right. So no need to check for the other options. The right option is option number 1 only. Experience, receive and acquisize. Next is question number 120. Pick a sentence that is grammatically incorrect. My requirement is that everyone be punctual. The flock of geese have 30 birds. Either the table or the chair needs to be fixed. The Union of Carpenters advocates for better pay. So my requirement is that everyone be punctual. Right, this one is right. There is no grammatical error. But look at the second option. The flock of geese have. Here it is mentioned have and flock. They are talking about flock. Whenever you talk about a group of something, then the helping verb that you use is always singular one. Has 30 birds. The right answer is option number 2. Okay, next is question number 121. Hardly had we entered dash it started pouring. Options are then, when, and lest. So hardly had we entered when it started pouring. Right answer is option number 2. Question number 122. Scarcely did I fall asleep dash my phone rang. Then, when, and or lest. Here is also the right answer is when. Next is question number 123. No sooner had I sat down dash the bell rang. Same options are here also. The right answer for this one is then. No sooner had I sat down then the bell rang. Next is question number 124. She has dash sense. There is dash money in the purse. We do not sell dash then 1 kilogram of tea. So look at the options. Any, some, little, much, any, more, little, some, less, little, some, fewer. So let's see. She has little sense. Okay. There is some money in my purse. We do not sell fewer than 1 kilogram of tea. So according to this is the right option is option number 3. Next is question number 125. He said, where is the station? The above sentence can be expressed in indirect speech. The question is about indirect speech. He inquired was the station. He asked where is the station. He asked where was the station. He inquired where the station was. Right answer for this is option number 4. Where is the station? So this thing is enquiry, right? So instead of where, we will use the word inquire, and the sentence is present continuous. So in indirect sentence it will become past continuous, and rest of the words are same. Next is question number 126. Geeta and dash went to Delhi. Between you and dash, he is a liar. Let you and a dash work together. Let's see what will be the right answer. Geeta and I went to Delhi, right? Between you and me, he is a liar. Let you and I work together. Right answer here is option number 3. Okay, let's come to the next question. I shall meet her without dash delay. Further delay. Delhi is dash from Mumbai, then Surat. The second sentence is talking about the distance. Okay, next is he had nothing dash to say, and fourth option is you need not go dash into the matter. So I shall meet her without further delay. Okay, and Delhi is, here is distance. So in distance we use far, so farther. And next is he had nothing further, again further. And last is you need not to go further into the matter, so further, same. So according to it, what is the right option? Option number 2, further, farther, further. Okay, next question number 128. Again the similar kind of question. The word is later, latest, or letter. So let's see the question. This is a dash edition of the book. This is the dash news. I could not hear the dash part of his speech. This is a later. This is the latest news, and I could not hear the latter part of his speech. So the right answer is option number 3. Question number 129. The word dilettante means what? Amateur, diligent, serious, or depraved. The right answer is amateur. Next is question 130. He is so weak dash. The above sentence could be completed most appropriately by adding what? So we have to just complete the sentence. He is so weak that he cannot walk. Right answer is option number 4. Next is question 131. The thieves dash the police. In his speech, he dash to a great person. He dash me into lending him my car. Check out the option. The thieves eluded the police. In his speech, he eluded the great person. He deluded me into lending him my car. The right answer here is option number 2. Eluded. What is the meaning of eluded? Eluded means escape. So the thieves escape the police basically, you know. And what does the eluded means? If we speak these words, then these both pronunciation are same, but the meaning are totally different. Like eluded means escape. This eluded means avert or touch. Okay, avert, make a more or less disguised reference to. So in his speech, he alluded to a great person, like he gave a hint of, or given a disguised reference of. Next is next word. What is the next word? It is deluded. What is the meaning of deluded? Deluded means be false or dishonest. So he dashed me into lending him my car. So what did he do? He deceived. So here the correct meaning will become deceive, being false to someone, okay, deceiving someone. Come to the next question. Question number 132. The judge exceeded dash my request. The master dispensed dash the services of his servant. Nobody is free dash faults. So the right answer here is option number 4. The judge acceded to my request. The master dispensed with, and nobody is free from. In most of the cases with the word free, the term used will be from. Okay, so right answer is option number 4 for question number 132. Next is question number 133. Impecunious means what? Options given are impartial, imprudent, without money, and senseless. Impecunious, if you have heard the term pecuniary, it is related to money. So pec is somewhere related to money. So impecunious means without money. So right answer is option number 3, without money. In next question, question number 134. We do not care a fig for her, writes some unknown correspondent with a pretty little handwriting and a pink seal to her note. She is faded and insipid. So whatever the question is, let's come to the options. The tone of the above passage can be best described as what? So it is option number 1. The right answer for this question is option number 1, ironical. Next is question number 135. To have a chip on one's shoulder means what? Means to be arrogant. Option number 2, to be arrogant. Next is question number 136. A suit is dismissed wrongly on the ground of being barred by limitation. The order of dismissal would operate as a res judicata and a bar a subsequent suit on the same cause of action. The above statement is true or false, or it would depend upon the facts or circumstances of each case. Well, the above statement is true. If you see the section 11 of CPC, which talks about res judicata, it is mentioned in the first paragraph only that no court shall try any suit or issue in which the matter has been directly and substantially in issue in the former suit between the same party. It will be barred. Right, now the next question, question number 137, which is Order 7, Rule 11 of CPC provides for what? Rejection of the plaint, return of plaint, dismissal of suit, or all of the above depending upon the facts of the case. Well, Order 7, which talks about what? Order 7 talks about plaint. Order 7, Rule 11 talks about the rejection of plaint. Right answer is option number 1. And where is the return of plaint mentioned? It is mentioned under the same Order 7, Rule what? 10. There return of plaint is mentioned, and dismissal of suit is not mentioned under order 7. It is mentioned under order 9, Rule 2, dismissal of suit. Okay, now the next question, question number 138. In a suit for recovery of rupees 25 lakh, the defendant files its written statement and pleads that it does not owe any money to the plaintiff, but in fact it is entitled to recover the sum of rupees 40 lakh from the plaintiff. The defendant, however, does not file a counterclaim. So here counterclaim and a written statement. Can the defendant file the counterclaim as a subsequent stage in the suit, or file a fresh suit seeking recovery of 40 lakh rupees? So written statement and counterclaim, which section talks about this? These are mentioned under order 8. Written statement, counterclaim, set off, all these things are mentioned under order 8. This thing is mentioned under order 8, Rule 6A. So the right answer here is the defendant can file both, either counterclaim or a suit. Right answer is option number 3. Next is question number 139. A files a suit for partition in the High Court of Delhi against her brother B. B relies upon the will executed by his father, bequeathing the entire estate in his favor. Here B has to necessarily file a counterclaim seeking probate of the will or an issue will be framed as to the genuineness and the validity of the will which B can establish without seeking probate, B has to necessarily file a separate probate petition, or option 4, the suit for partition will be stayed until B obtains a probate. So this thing is basically order 14 talks about framing of issues, and order 14 rule 3 talks about materials from which issues may be framed. So when the content of a document is produced, which is a will, and the party is relying upon that, then in such a case an issue will be framed. So the right answer is option number 2. An issue will be framed as to the genuineness and the validity of the will which B can establish without seeking probate. Now next question is question number 140. In a non-commercial suit, when issues both of the fact and law arise and the court is of the opinion that the suit may be disposed of an issue of law only, the court can frame issues of law and facts and adjudicate the issues of law, and as preliminary issue frame issues of both of fact and law and decide all the issues together, frame issues only on the issues of law and postpone the settlement of other issues, or both 1 and 3. When there is a issue of fact and law, then the court has the option to choose any, either option number 1 or option number 3. So basically the court can choose that framing the issues of law and facts and adjudicate the issues of law as preliminary issue, or framing issues only on the issues of law and postpone the settlement of other issues. So the right answer is option number 4. Next is question number 141. For the purpose of amendment of pleadings mentioned under order 6 rule 17. Order 6 is pleadings and 17 talks about amendment of pleadings. The commencement of trial takes place when the issues are framed, when affidavits in evidence are filed, when the affidavits in evidence are tendered by the witness, or once the cross examination begins. The right answer is when the issues are framed, and it is mentioned under the same rule. And now next question number 142. X files a suit against Y, which is a partnership of 4 private individuals. X does not issue notice under section 80. Notice mentioned in section 80 of CPC. The suit cannot be dismissed for non-compliance, has to be dismissed for non-compliance, can be dismissed as a discretion of the court if the circumstances require a notice, or such suit plaint will be rejected. Well, the answer is option number 1, cannot be dismissed for non-compliance. Why? Because section 80 says that the notice should be only given to government, and here it is a partnership of 4 individuals. Now come to the next question number 143. An ex parte decree passed by the court A was transferred to court B for execution, which execution proceedings are pending in the court B. Court A sets aside the ex parte decree, and on a rehearing a fresh decree was passed on the same terms. So here, since the new decree is on the same terms as the decree which was set aside, the execution proceeding will continue, or court B can continue to execute the ex parte decree since the order of transfer has not been recalled. Basically, this thing is mentioned under section 42 of CPC, and according to which the execution proceedings in the court B come to an end, and a fresh execution petition would have to be filed of the new decree. Okay, the right answer is option number 4. Now come to the next question number 144. In a commercial suit, the time limit of 120 days for filing a written statement can be extended if the defendant shows adequate reasons for non-filing, can be extended at the discretion of court, cannot be extended under any circumstances, can be extended and with the imposition of heavy costs. Well, earlier I told you that written statement is mentioned where? Under order 8 rule 1. Well, this is a special amendment related to commercial suit which came through Commercial Courts Act 2015. Where the maximum time limit for filing written statement is 120 days, whereas in general suits it is only 90 days. So the right answer is cannot be extended under any circumstances. It's mentioned there for commercial suits only. Next is question number 145. When the plaintiff appears and the defendant fails to file written statement, again written statement, same order, despite a service, the court shall pronounce judgment under order 8 rule 10. may either require the plaintiff to prove its case by leading evidence or pronounce judgment against the defendant depending upon the nature of the case, shall necessarily require the plaintiff to prove its case by leading evidence, direct personal appearance of the defendant. Well, the right answer for is this second option, may either require the plaintiff to prove its case by leading evidence or pronounce judgment against the defendant. And this thing is mentioned where? It is mentioned under Order 9, Rule 6(1), which talks about procedure when the plaintiff appears. Next is question number 146. Where an interim injunction has been granted without notice to the opposite party and the plaintiff fails to comply with the provisions of 39 Rule 3 of CPC, the ex parte injunction lapses on the expiry of the time for compliance. Ex parte injunction would necessarily be liable to be vacated. The court can extend the time for compliance of Order 39 Rule 3 even after the defendant has appeared and filed a written statement. Or option 4, the ex parte injunction would be vacated if the non-compliance is prejudicial to the defendant. Then this thing is mentioned under Order 39. First of all, what is Order 39? It talks about temporary injunctions and interlocutory orders. And Order 39 Rule 4 says that if the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless for the reasons to be recorded it considers that it is not necessary so to do in the interests of justice. So the right answer is option number 2. The ex parte injunction would necessarily be liable to be vacated. Next is question number 147. Issues are framed by the court. Onus of some of the issues is on plaintiff, and of some of the issues the onus is on the defendant. The plaintiff has to file its affidavits in evidence on all issues or file its affidavits in evidence in affirmative on issues onus whereof is on plaintiff, and the evidence in the negative on the issues onus whereof is on defendant. Order 18 Rule 4, which talks about recording of the evidences, and Rule 4 says that the plaintiff has to file its affidavits in evidence where the onus is upon the plaintiff. So the right answer for this is option number 3. File its affidavits in evidence in affirmative on the issues where the onus is upon the plaintiff. Now next question, question number 148. X leases Y a property for 10 years from year 2000 to 2010 where the rent is payable on the 10th of every month. Y does not pay any rent from the inception of the lease. X sues in 2011 for the arrears of rent from 2005 to 10 only. Then X can thereafter file a fresh suit for arrears of the rent from the period from 2000 to 2004, or X can amend the plaint to include the recovery of rent from 2000 to 2004, or X claims for arrears of rent would be restricted for a period of 3 years prior to the institution of suit. Or option number 4, X not having claimed rent from 2000 to 2004 is barred from claiming the rent for subsequent period. Well, this is mentioned under Article 52 of Limitation Act. Article 52 of Limitation Act. Okay, and according to that article, the right option becomes option number 3. X claims for arrears of rent would be restricted for a period of 3 years prior to the institution of suit. Next is question number 149. In a suit under Order 37 CPC, what does the Order 37 talks about? This talks about summary suit. The court grants the defendant conditional leave to defend subject to the defendant securing the suit amount by way of a bank guarantee. The defendant fails to furnish the bank guarantee in the prescribed period. The court shall permit the defendant to file written statement, convert the suit in ordinary suit, decree the suit against the defendant, or direct the plaintiff to lead the evidence. Well, the right answer for this is option number 3, decree the suit against the defendant. Next is question number 150. A supplies goods from Delhi to B at Mumbai under a contract which provides courts in Mumbai would have jurisdiction to deal with disputes arising out of this agreement. A sues B in a court at Delhi for outstanding balance. Now options are: first, the court would not admit the plaint owing to the jurisdiction clause in the contract. The suit would be admitted and only if B raises an objection to jurisdiction at Delhi would the court determine the same. B can prefer an appeal against the order of admission of the suit at in the court at Delhi, B can approach the Delhi High Court for the transfer under section 24 of CPC. According to section 21 of CPC, the suit would be admitted and only if B raises an objection to jurisdiction at Delhi would the court determine the same. And what does section 21 of CPC talks about? Objection to the jurisdiction. The court in which the suit is pending, only that court can decide the matter of objection to jurisdiction. Now next question number 151. A is a resident of Delhi, files a suit at Delhi for infringement of trademark by B, a resident of Mumbai, for using the mark at Mumbai. This is what? It is a section 20 of CPC, which talks about other suits to be instituted where the defendants reside or cause of action arises. So right answer for this is question number 153. A decree for permanent injunction restraining the defendant for interfering with the possession of plaintiff, finding the possession of plaintiff to be settled, would operate as res judicata in a suit for partition filed by the defendant for the same party. Res judicata with section 11 of CPC. Would it operate as res judicata or not? The right answer for this is option number 2. No, would not be operated as res judicata in a suit for partition. Now next is question number 154. On the receipt of application for execution of a decree, if the requirement of order 21 rule 11 to 14 have not been complied with, the defects or are not remedied, then the court shall reject the application or allow process of the application for execution, or option 3 or 4. Well, application for execution of a decree, which rule of order 21 talks about it? Rule number 17, application for execution of decree or orders, right? So according to that rule, the court shall reject the application for execution. Right answer is option number 1. Next is question number 155. A holds a decree against B for 5,000 rupees. B holds a decree against A for 3,000 rupees. Both A and B apply for execution of decree to the court which has jurisdiction to execute both the decrees. The court may allow execution of A's decree of rupees 2,000. Right answer is option number 1 only, and it is mentioned where? Order 8 rule 6, which talks about a written statement set of counterclaim, right? So this is set off. Next is question number 156. The period of limitation for an application to restore a suit dismissed for default of appearance is how much days? It is 30 days from the date of dismissal. Option number 1. Period of limitation for application to restore suit dismissed for default of appearance is 30 days from the date of dismissal. Next is question number 157. Where a suit is dismissed for non-appearance by the plaintiff and the defendant is not yet served, or after service of the defendant both parties do not appear, then the plaintiff may bring a fresh suit for the same cause of action, apply for an order to set aside the dismissal, file an appeal, or option 4, either 1 or 2. Well, this is mentioned under order 9 rule 4. And according to that, it is option number 4. Bring a fresh suit for same cause of action and apply for an order to set aside the dismissal. Order 9 rule 4 talks about plaintiff may bring a fresh suit or court may restore suit to file. Next is question number 158. A granted an injunction restraining B from the use of a trademark. A alleged that B had willfully disobeyed the injunction order. B pleaded that he had no knowledge of the injunction order. Evidence was non-conclusive. The court shall order option A, property of B to be attached. Option B, B to be detained in civil prison. B, to compensate A by damages, or option D, none of the above. Again, this is from order 39. The right answer will be D, none of the above. Temporary injunction and interlocutory orders, order 39. Next is question 159. A decree shall not operate as res judicata. Res judicata, again section 11. When judgment is passed by a court which does not have subject jurisdiction, judgment is obtained by fraud if collusion is proved between parties, or all of the above. Right answer is all of the above, option 4. Next is question 160. A filed a suit against 3 defendants. Defendant 1 alleged that there was no cause of action against him under order 7 Rule 11D CPC, the plaint to be rejected in whole, rejected in part if the cause of action is not joint and several, proceeded against all the defendants or none of the above. Well, what does Order 7 talks about? Order 7 is about plaint, and Rule 11 is what? Rejection of the plaint. Here the right answer is option number 3, proceeded against all the defendants. Basically, there is a general principle of law that whenever court is considering the plaint on application for rejection, Rule 11 which talks about rejection of plaint, and then it should be considered as a whole and not in parts. Therefore, out of 3 defendants, if only one defendant filed for rejection, it cannot be rejected in parts. What will be the answer? It will be proceeded against all the defendants. The right answer will be option number 3. Next is question 161. In a civil suit coming up for admission, if the court does not have subject jurisdiction to grant relief in the suit, the court cannot grant interim relief under Order 39 CPC, or can grant relief under the same order, has to nevertheless issue summons to the suit, has to frame a question of law and refer it to High Court. Well, it is option number 1, cannot grant interim relief under Order 39, which is temporary injunctions. It is again the same thing, general principle of law. The court having jurisdiction have the power to decide the case here, right? Next is question number 162. In a suit for permanent injunction against a defendant company, the plaintiff sought an interim injunction. Again, Order 39 interim injunction. Both these questions are from same order. Interim injunction restraining the defendant from prosecuting the suit in a foreign court. Options are: a temporary injunction can be granted restraining the foreign court from proceeding with the suit. Temporary injunction restraining the foreign court can be granted if there is a prior pending suit in India, irrespective of where the defendant resides or carry on the business. Or option 3, a temporary injunction restraining the defendant from prosecuting the foreign suit can be granted if the defendant is amenable to the jurisdiction of the court, or all of the above. The right answer is option number 3. Next is question number 163. An order passed under Order 39 Rule 1. See, there are 3 questions which have been asked from Order 39. Rule 1, CPC can be challenged by filing an appeal. Option 1 is the right answer here. Next is question number 164. Under Order 9 CPC, where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action, or the plaintiff may apply for an order to set the dismissal aside. Or option 3, the plaintiff may bring a fresh suit in the respect of same cause of action. Or option 4, either 1 or 2. Right answer here is option number 4, either 1 or 2. The plaintiff shall precluded from bringing fresh suit in respect of same cause of action, or the plaintiff may apply for an order to set aside the dismissal. And where this thing is mentioned, it is mentioned under Order 9, Rule 9. Next is question number 165. During the pendency of an appeal by the 4 defendants in a suit, one of the appellants dies and no step for substitution of his legal representatives are taken, and the appeal in so far as it relates to the said appellant abates. The 5 respondents apply for dismissal of the entire appeal as abated. Answer whether. So basically this one is also a general principle of law decided in several precedents. The right answer here will be option number 2. The entire appeal abates only if the cause of action against all the defendants was won, and allowing the appeal of the other defendants would lead to inconsistent decrees. Next is question number 166. The court at the first hearing of the suit. Option 1, can only frame issues. Option 2, may permit cross-examination of either party by the other. Option 3, to elucidate the matter in controversy in the suit, may examine either of the parties, or none of the above. Well, this has been asked from Order 10, Rule 2(1)(a). What does Order 10 talks about? It is examination of the parties, and according to that, right answer is option number 3. To elucidate the matters in controversy in the suit, may examine either of the parties. Next is question number 167. Failure of judgment debtor to file affidavit of the assets under Order 21 Rule 41(2) of the CPC results in what? In civil imprisonment up to 3 months for the judgment debtor, and it is mentioned under same order but Rule 41 Subrule 3. Next is question number 168. Now the questions from CPC have ended, and it is from Constitution. The Vice President is elected. Where is election of Vice President mentioned? It is under Article 66. Right answer here is option number 4. by electoral college consisting of all the members of both houses of parliament in accordance with the system of proportional representation by means of single transferable vote and a secret ballot. Next question number 169. There is no fundamental right of a person arrested not to be detained in custody without being informed as soon as may be of the grounds of such arrest or for the period beyond that of 24 hours of such arrest, excluding the time necessary for the journey from place of arrest to the court without the authority of the magistrate. Option 1, in case of one who for the time being is an enemy alien, or in case of one who is arrested and detained under the law, under any law providing for the preventive detention. Well, this thing is mentioned where? Under Article 22 clause 3, exception. If you see the exception, right, exception to this article, then according to that, right answer is option number 3, both 1 and 2. Next is question number 170. An amendment of the Constitution of India to make change in provision relating to establishment and constitution of the Supreme Court requires before giving of assent by the President. Amendment is mentioned in Article 368. And the proviso of clause 2 provides that ratification by the legislatures of not less than one half of the states by resolution. In certain cases mentioned in the proviso, and proviso clause B mentions that chapter 4 of part 5, which is Union Judiciary and Supreme Court. So the amendment relating to Supreme Court shall be option number 3, both 1 and 2. That is to be passed by a majority of not less than 2/3 of the members present and voting in each house, and ratification by resolution to that effect by legislatures of not less than one half of the states. An ordinance promulgated by the President of the India in exercise of his legislative power shall cease to operate or to have effect or to be of same force as an act of parliament. Then option 1, at the expiration of 6 weeks from reassembly of the parliament, upon passing of the resolution by one house of the parliament endorsing the disapproval thereof expressed by resolution of the other house, upon it being withdrawn by the president, or all of the above. Right answer is all of the above, and it is mentioned where? Under Article 123. Now questions from contract. Question number 172. If only a part of single consideration for one or more objects is unlawful, the contract shall be valid to the extent the same is lawful, void to the extent the same is unlawful, void as a whole, or valid as a whole. And this thing is from section 24 of Contract Act. And it says that if the consideration and objects are unlawful in part, if any part of a single consideration for one or more objects, or any one or several consideration for the single object is unlawful, the agreement is what? Void. So the right answer is option number 3, void as a whole. Next is question number 173. A letter of acceptance sent by the post is lost in transit. Then option 1, there is a concluded contract as the letter of acceptance is put in the course of transmission. There is no concluded contract as the acceptance has not come to the knowledge of the proposer. There is no concluded contract as the acceptance has not been communicated to the proposer, or none of the above. Well, this is asked from which section? Section number 4, acceptance. What does section 4 signify? It signifies that communication of an acceptance is complete as against the proposer when it is put in the course of transmission to him so as to out of the power of the acceptor, and as against the acceptor when it comes to the knowledge of proposer. So the right answer is option number 1. There is a concluded contract as the letter of acceptance is put in the course of transmission, and it is basically what? A postal rule. Now next is question number 174. A and B go into a shop. B says to the shopkeeper, let A have the goods, I will see that you are paid. Here the contract is of what? It is basically section number 126. It is the contract of guarantee. Next question number 175. An agreement in restraint of trade. Which section says that? Section 27. Agreement in restraint of trade is valid, void to the extent of restraint, or option 4, voidable. Right answer is option number 3, void to the extent of such a restraint. Next is question number 176. If the compensation to be paid on a breach of the contract is genuine, the pre-estimate of the prospective damages is known as what? Liquidated, unliquidated, special damages, or penalty. Well, it is liquidated damages, and it is from section 73 and 74 of Indian Contract Act. Next is question number 177. If the time of performance of the contract is of essence, the promisor fails to perform his part by the specified time, the contract becomes what? Void, voidable at the option of promisee, infructuous or valid. But it is voidable at the option of the promisee. Yeah, promise likha hua na, correct it becomes promisee. So right answer is option number 2. Next question is from agency. Question number 178. An agency is terminated by the principal revoking the authority of the agent, agent renouncing the business of agency, death of the principal or agent, or all of the above. Right answer is all of the above, and it is mentioned where? Section 201, agency, termination of agency. Next question, question number 179. Parties A and B have agreed on the seat of arbitration. Now questions from arbitration have started. The same can be changed by the arbitral tribunal unilaterally, cannot be changed at all, can be changed by the agreements of the parties, or cannot be changed by the parties unless arbitral tribunal permits. The right answer is option number 3, can be changed by the agreement of the parties. Next question, question number 180. An application to set aside the arbitral award under the Arbitration and Conciliation Act 1996 may be made within the time period of the following number of days that have elapsed from the date on which the party making the application had received the arbitral award. How much time is there? See the section 34 subsection 3. Then the right answer is there, 3 months is mentioned there. An application for setting aside may not be made after 3 months have elapsed. So right answer is 3 months. Next question, question number 181. An arbitration agreement entered into on 1st of August 2019 provides for arbitration to be in accordance with Arbitration Act 1940. The arbitration would be governed by the provision of Arbitration and Conciliation Act 1996. Arbitration would be governed by the provision of Arbitration Act 1940. Arbitration clause is void, or option 4, arbitration would be governed by the provision of Arbitration Act 1940 as well as of 1996. Well, section 85 of Arbitration Act talks about repeal and savings, and according to that, option 1 is the right answer. Next is question number 182. An arbitration agreement expressly ousts the jurisdiction of consumer forum. In such a case, only arbitral tribunal will have jurisdiction, only consumer forum will have the jurisdiction as a special act, or option number 3, both fora. It is not fora, it is forums, FORUMS. It is a spelling mistake in the question. Or option 4, the clause would be void and only a civil suit would lie. If you see the option 3, then both forums will have jurisdiction to adjudicate the disputes. The right answer is option number 3. Next question, question number 183. An arbitration clause contained in a deficiently stamped and compulsorily registrable document, then it is enforceable even without deficient stamp duty being paid. It is enforceable only if the deficient stamp duty along with the penalty, if any, is paid, is invalid. Or option 4 is enforceable only if the deficient stamp duty along with the penalty, if any, is paid and the document is registered. So it is option number 2 is enforceable only if the deficient stamp duty along with the penalty is paid. Next is question number 184. A non-signatory to the arbitration agreement can be made party to the arbitration proceedings. First of all, where is arbitration agreement? Arbitration agreement is in section 7 of the act, right? Always, never, under some circumstances or ground, only on the application of such non-signatory. The right answer is under some circumstances or the grounds. Option number 3. Next is question number 185. In a pending arbitration case, the arbitral tribunal passed an order of interim injunction under section 17. Section 17 talks about what? Interim injunctions by the arbitral tribunal of the Arbitration and Conciliation Act 1996, restraining encashment of a bank guarantee. The aggrieved party has the following remedies: file a review before the arbitral, or option 2, file an appeal under section 37 of the act. Right answer is file an appeal under section 37. Next question, question number 186. Disputes between A and B are referred to arbitration under the act. The final award is rendered on 1st June 2019 in favor of B. During the ensuing summer vacations of the court, an urgent situation arises in which B wishes to seek interim relief. Here B is seeking interim relief, so B can approach the arbitral tribunal under section 17 or approach the court of competent jurisdiction under section 9. Or option 3, not obtain any interim orders as the final award has been passed. Or option 4, approach the Supreme Court for interim orders. Right answer is option number 2, approach the court of competent jurisdiction. And section 9 talks about what? Interim orders, interim measures by the court. Next is question number 187. Under section 8 of Arbitration Act, the reference of parties to arbitration is what? Is mandatory. And what does section 8 talks about? It talks about the power to refer parties to arbitration where there is an arbitration agreement. Next is question number 188. A nomination of an arbitrator is made by a person who is himself ineligible to the act as an arbitrator under section 12 subsection 5 read with the 7th schedule of the Arbitration Conciliation Act. In such a case, the nominee cannot act as an arbitrator, or such a nomination would be void ab initio, or both 1 and 2. Well, the right answer is option number 3, both 1 and 2. And what does section 12 subsection 5 talks about? It says that notwithstanding prior to any agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as an arbitrator. And proviso, what does proviso says? It says that parties may subsequent to disputes have arisen between them waive the applicability of this subsection by express agreement in writing. Okay, right answer option number 3. Next is question number 189. A petition for execution of arbitral award for recovery of money by attachment and sale of immovable property of judgment debtor at Delhi is filed at New Delhi, though the objection against the arbitral award were dismissed by the court at Ludhiana and without seeking transfer from the court. Would the execution petition be maintainable? Yes, it is maintainable. Next is question number 190. The parties to the arbitration agreement are residents of Lucknow and Kolkata. The contract was performed at Varanasi. The parties agreed that arbitration proceedings will be conducted at New Delhi and were held at New Delhi. Where will the petition under section 34 of the act will be filed? It will be filed where? It will be filed at Delhi only. Right answer is option number 1. And what does the section 34 talks about? Section 34 talks about application for setting aside of the arbitral award. Okay. Next is question number 191. An application under section 8 of the act is filed by the defendant. First of all, understand what does section 8 talks about? Power to refer parties to arbitration where there is an arbitration agreement. An arbitration agreement is under section 7 of the act. Is filed by the defendant after the defendant has filed a written statement on merits and after framing of the issues in which no issue qua arbitrarity is framed. The court must what? Must dismiss the same as not maintainable. Right answer is option number 3. Next is question number 192. A petition under section 34 of the act is filed on the 41st day after the expiry of a limitation period prescribed under section 34 subsection 3 of the said act, along with an application for condonation of delays in filing thereof. The petitioner makes out a sufficient ground of condoning the delay. The court must what? The court must dismiss the application for condonation of delay as well as the petition under section 34 of the Arbitration Act on the ground of limitation. Right answer is option number 3. Next is question number 193. A petition under section 48 of the act against foreign award must be filed before whom? Before district court having territorial or pecuniary jurisdiction, or before the high court? Well, it is before the high court, section 48. Next is question number 194. The petitioner in a petition under section 34 of the act shows that another method of calculating damages was preferable than the one adopted by the arbitrator. The court must dismiss the petition. Right answer is option number 3. Dismiss the petition. Next is question number 195. A institutes a suit against B with respect to the disputes arising out of an agreement entered into with B. The said agreement provides for arbitration of all the disputes, including the dispute subject matter of suit. The court before which the suit comes up for the admission will dismiss the suit, will refer the dispute and the parties to arbitration, will admit the suit if otherwise not maintainable by law. Or option number 4. Well, the right answer is option number 3. Will admit the suit if otherwise maintainable in law. Next is question number 196. A has let out his property at Delhi to B at a rent of rupees 3000 per month on the terms and conditions contained in stud lease deed. And you can read out the question, no, the whole question. Well, come to the options. The arbitral proceedings are maintainable or not maintainable, or maintainable only if B does not object the same. Or option number 4, the arbitral proceedings are maintainable with the express contents. Well, the arbitration proceedings here are not maintainable. Option number 2. Next is question number 197. A files a suit against B for recovery of money due under the agreement, term whereof has since expired by affluence of time. B files an application under section 8 of the Act contending that the agreement contains an arbitration clause. The court would then what? Then refer the parties to the arbitration. Right answer option number 2. Next question number 198. The bar under section 42 of the Act is not applicable to whom? Application under section 8 of the said Act, right? Under section 11, an application under the Act filed in a court that has no subject matter jurisdiction. Well, the right answer here is all of the above. Next question number 199. On the very filing of the petition under section 34 of the Act for set aside of an arbitral award in arbitral proceedings which has commenced after 23rd December 2015, the arbitral award becomes inexecutable, or the arbitral award is eclipsed, or the arbitral award remains executable unless execution thereof is stayed by the court before which the petition is filed, or option number 4. Well, the right answer here is option number 3. The award remains executable unless the execution is stayed by the court. Next question, last question number 200. An arbitration agreement provides for arbitration under the Act by 2 arbitrators. One is appointed by each party. Then the arbitration agreement is void or is of arbitration by 3 arbitrators with 3rd arbitrator to be appointed by the court. Or option 3, the arbitration agreement is of arbitration by 1 arbitrator, either to be appointed jointly by the 2 parties and if not by the court. Right answer is option number 3. And which section talks about the appointment of arbitrators? Section number 11. So section number 11 subsection 3 says that a person of any nationality may be an arbitrator. So basically it gives the conditions to become an arbitrator. So with this, the paper is completed of year 2019. I hope you like the video, and if you like the video, then please hit the like button and share and subscribe to our channel Law and GK. And if you have any query, then you may ask it in the comment section. Thank you very much.